Policy responses. What is policy response? I just want to make clear what we're going to talk about. It's not about everything, as the name could imply. It's about the way how we think competition law is operating in the regulatory environment, which is dealing with the digital economy. Digital economy is a complex phenomenon. As a complex phenomenon, it's regulated by complex institutions, but complex ecosystem of regulations, actually. And I would refer to the business ecosystem. There is an institutional ecosystem. So there is a bunch of norms and institutions which try to address challenges coming up from digital economy, from inequality to efficiency, personal data, and other sorts of data, and industrial policy, of course, last but not least. And industrial policy considerations becoming more and more important in the discussions about future of the digital economy. We constantly seeing and hearing this argument in the competition debate as well, because industrial policy approach going very close to competition considerations. And when we talk about merger review, we're saying about this bargaining going on between corporations and authorities, and corporations are constantly blaming authorities they too much of industrial policy considerations in remedy approach. But at the same time, companies themselves, and we saw it in Siemens-Alstom proposed merger, they insisting that authorities have to consider industrial policy goals and objectives in the merger review. In the same story happening with conduct investigations, that we see that United States is very loose in approach towards digital giants, so they try not to touch them and interfere too much in their businesses. And probably the main reason of this is because those are American giants. So if they would be, I don't know, Chinese giants or Japanese giants or even European giants, probably there would be more aggressive competition policy on the US side. I mean, that's my intuition, and there is a lot of evidence about this, I think, in expert community as well. So for the BRICS countries is extremely topical issue as well, because what we see in BRICS countries, most of the countries, they came from central planning economy. And those economies were for years operating under some sort of central plan framework. So, and this planning is intrinsically present in mindsets and thinking of the policymakers. So it's very difficult to change it. And the question we ask ourselves now, whether we have to change it, considering that digital economy brings, some sort of new modality in terms of regulation of the market behavior. Some people even call it digital socialism or calculation debate in socialist economy, which was a major part of socialist debate when they are thinking how to calculate everything, plan everything. So this calculation enterprise is getting more and more present in the modern capitalist world, with digital platform trying to calculate and predict everything with big data and algorithms they have in their hands. So basically this digital socialism hope or digital socialism proposition, which is present, clearly present, also brings us to this discussion about industrial policy in the context of digital economy. So now that's basically a scope of our discussion. It's very broad, as you see, but at the same time it's focused, because it targets the core of the digital economy competition law challenge, how to transform competition law to make it operational, useful, and at the same time, really addressing the main challenges of the digital capitalism as we know it, and as we will know it tomorrow, because it's constantly evolving. It's a moving target. So we start with Svetlana Golovanova, who is professor of economics here at High School of Economics, but of campus from Nizhny Novgorod, which we are big in a university. We have campuses all around the country. So this is one of our major campuses in Volga region of Russia. And Svetlana was very actively involved in the preparation of in drafting of the digital report on Russian side, and great scholar and person. So please.
Well, actually, as many participants of this session, I'm glad that I had an opportunity to participate in this great, very important international project devoted to challenges to competition policy in digital area. Actually, results of our study were already presented by my colleagues, by Eduarda Ribeira, by Svetlana Avdasheva. So I do not actually plan to repeat, as our findings are already mentioned. I'd rather like to pay attention to some specific topic which is related to the topic of our session, global policy responses. I'd like to stress the importance of collaboration between competition authorities of different countries. This situation is so that in digital economy it becomes more and more important. But it's not only about digital economy. It is obvious that when countries have different interests, it would be naive to expect that they will cooperate. For example, collusion might be beneficial for one country and it can be harmful for another one. So it is highly unlikely that they'll undertake some collaborative actions. But even if they have the same interests, when their interests coincide, collaboration might not be possible in case institutional environment is different in different countries. And it is quite often so. And another project, not this one, but another project which we had this year at Laboratory of Competition and Antitrust Policy of High School of Economics, was devoted to this particular topic. And we undertook analysis of competition laws of Brics countries. And the main finding, and it is not surprising, is that general understanding and general vision of anti-competitive conducts are very similar between the countries, while approaches they apply to prove that it was some violation of competition law are quite different. I mean, first of all, legal standards, which can be per se or which can be based on rule of reason, on some efficiency analysis. And comparing competition law of different countries, of Brics countries, we found that, for example, when we are talking about collusion, the hardcore collusion or cartel, well, there is no difference, and Brics countries consider it illegal, certainly illegal per se, so no any provement is needed. While when we are talking about, for example, abuse of dominance, and we started to discuss this topic at the end of the previous session, the situation differs dramatically. As, for example, in Russia, India, China, abuse of dominance cases are considered illegal per se, so no some advanced analysis is needed to prove violation. While in South Africa and especially in Brazil, it is not so. They apply effect-based approach. And it is especially, the difference is especially dramatic in respect to excessive prices, because, for example, Brazil does not correspond it illegal itself. As competition authority, CADE considers decides that it is impossible to identify fair price. And if it is so, it is impossible to punish some company for unfair price. While in Russia, for example, this type of conduct is illegal per se. So no improvement, minor improvement is needed to find a company guilty in violation of competition law. Well, so results of our analysis indicate that anti-competitive conduct is unlikely to become the focus of coordinated actions, while situation is different when we are talking about mergers. As legislation is more or less harmonized between countries, so collaboration in this sphere is possible. And actually, Bayer-Monsanto case, very famous case, which was not discussed today, but I hope it will be discussed during the main conference, shows that competition authorities communicate and collaborate and pay attention to decisions made by other authorities making their own decisions. Well, for example, among Brics competition authority, South African one was the first which imposed remedies, and they included structural remedies and requirement of commercialization of gene technology. The next one was Brazil. Again, we can see structural remedies, and they were combined with a ban on use of exclusive sales channels, tie-in sales, and bundling, as well requirements on non-discriminatory licensing were introduced. The most radical remedies were imposed by China. Again, we can see a wide list of structural remedies, and the list of market is much wider than in previous cases. But in addition, we can see that any company that operates a digital agriculture platform is obliged to provide access to all Chinese agriculture software and application developers. So these remedies are much more stronger, and at least Russia. Russia made one step further by requiring non-discriminatory access not only to software but also to databases collected by digital platforms. So we can see that remedies become stronger and stronger, so competition authorities pay attention to previous experience and add something else. That is an example of collaboration, so it saves efforts, of course, for them, saves time, and gives them some common vision of situation and what they can do in this situation. And as it was already mentioned, in digital area, collaboration between competition authority becomes even more important as new business practices, new types of products and services, new business models appear. And competition authorities need to collaborate to deal with this, to develop new tools, new approaches, and to harmonize their approaches. And one example, which was already discussed, is, for example, just market definition in case of platforms. Several presenters already mentioned it. There is no common vision on types of platforms that can exist, and even on the number of markets that should be considered in this case. Should it be one multi-sided market, or should we consider several interrelated markets? So this should be discussed between competition authorities, and that is a good area for them to communicate. Well, some more ideas that appeared during the previous sessions, just some words. Well, about guidance. As Yes, when we are talking about abuse of dominance and digital companies which business is based on data, big data analysis, on internet communications, are quite often very big ones. And for example, in this case, it is not possible to apply a so-named equally efficient test, as you unable to find a company of the same size, and the size is often as a main factor that determines efficiency of the company. So some new approaches should be developed, and it was mentioned already that we should focus on dynamic competition. But there are no measures for dynamic competition at the moment. There is no common vision in this sphere. So, competition authorities should find instruments to support dynamic competition. And, for example, multi-homing requirements also were discussed in previous sections, but it's not the only way for cooperation. Well, a creative idea mentioned by Alexey Ivanov, that after some point there is no sense to spend efforts on development of remedies, as they will anyway be inefficient. And competition authorities should just start blocking mergers. Of course, there could be different point of views on these particular issues, but again, competition authorities should discuss it, should find some common decision, common approach, and if they find it reasonable, not to impose remedies, but just block mergers, it should be a result of their communication. So, and during the previous session, very interesting ideas were discussed, devoted to algorithmic collusion. Well, it's just a question which appeared during our communication, during coffee break. I just used my time to ask if it is possible to develop anti-collusive algorithm. So that is again some opportunity for competition authorities to collaborate in this digital era. So there are great perspectives, and let's hope we'll realize them. Thank you.
Thanks, Svetlana. It reminds me a little bit of vaccination of algorithms, yes? So we have to immunize them against collusion, so to put a sort of, or, there is also coding of alcoholics, so when alcoholics physically deterred from consumption. So thanks a lot for your thoughts about. I think it's very good also wrap up of what we were talking today during the day. It was very important to have this because I'm saying so many things we already discussed, like just in one day. So we can have like 50-day conference in this context. Yeah, eternal one. Next speaker would be from the men's side, Murilo. Murilo just recently finished his PhD, which was on actually intersection of different type of regulatory approaches with trade policy and competition and investment, and how basically governments have to pick, cherry-picking process for how to regulate economy, like with which tools. So please, Murilo. Murilo is based at UCL right now and teaching also in 25 other London-based universities.
Thank you very much, Alexey, and also for hosting me in the center as an expert for. It's been. And
Murilo was very actively involved in the preparation of the report. Sorry, I was just by default. It was implied in my mind.
So I was part of the team that drafted the Brazilian country report together with Paulo Furqui and Caio Mario. I also co-drafted parts of Chapter 1. And the idea here is to share some of the thoughts on the Brazilian perspective. Since this is a policy response, I'll bring some elements of Brazilian perspective. But also, I would like to highlight some of the common issues of all Brics countries And the key message will be what we figure out after the research, the difference between what the law of each of the countries allows in terms of what the authorities, competition authorities, can do in the digital markets, and what is and how is competition law actually applied in digital markets. And finally, the idea of how this Brics initiative and the report, the academic report that's going to be presented in a couple of days, how this report helps to understand this gap between what the law allows them to do and how is competition law applied. And the first thing is in relation to what has been done. So when it comes to the Brazilian case, we started to analyze all the cases for the past 15 years. And we chose that date because it's a way to understand how the competition law was applied. And it coincided with my entry into the competition authority in Brazil. And as an example, when I arrived in the competition authority, the first cartel case that I was supposed to analyze and set the decision that would bring the cartel to a specific outcome was a cartel in the taximeters inspection and maintenance. So 4 companies, very unsophisticated companies, got together and set the prices for the taximeters that was used in different taxis in the south of Brazil. So a quite straightforward casebook example. There was a fine. I was very excited because it was my first case. And flash forward, we have 15 years, we have different modes of delivery. You have Uber, you have Yandex. So these kind of modes of delivery are not the ones that will prevail, are not parts of the priorities in the current setting. So the first thing that we figure out is that the Brazilian institutional system is quite equipped to deal with all the issues that arise in digital markets in terms of how the law approaches the issue, both in conducts and in mergers. The law is wide enough to cover all types of practices. We've been discussing the example of algorithm collusion and all other examples of dominant position in digital markets. So the law is enough to deal with all those issues. But on the other hand, we figured out that Brazil was cautious for the past 15 years in its approach to digital markets. And picking up on a point that Alexey highlighted, on the other hand, Brazil was a bit active when it comes to internet access, when it comes to competition enforcement related to infrastructure that supported internet access. So these were parts of our conclusion. And the part of this gap is explained by a natural trend to be careful when analyzing these changing markets, and this leads us to what could this academic report bring to Brazilian analysis and analysis of all the other jurisdictions. And the idea is that the academic report will bring the theoretical underpinnings. It will bring the new theoretical approaches to substantiate any alternative ways of action from the authorities. So the main comparative advantage of the report is that it will offer a repertoire of solutions, of insights that might help the competition authorities to deal with those issues. And the comparative advantage of the Brics countries is that they have, as it was highlighted before, they have large domestic markets, actually huge markets, and there is some freedom to innovate in terms of the way that you approach this phenomenon, because you don't have a backlog of 100 years of case law that you have to follow a specific path. You don't have the constraints of a treaty as we have in Europe. So we have the freedom to innovate, to experiment, and with that, I believe that we are ready for a new era of competition enforcement with more grounds to substantiate all the enforcement activity. So I'll stop here. If you're interested in getting to know the Brazilian experience, the Brazilian report will be available if it's not already, and I'm happy to take any questions. Thank you.
Thanks, Murilo. And yes, it will be, I hope, available by tomorrow or the day after tomorrow, the latest, or Thursday morning, maybe the final deadline. The final deadline, Thursday morning. So, but you could read it later on. I mean, people don't read during the conferences, so they can read on Friday night, Saturday, weekend reading. Yes. So, and now we turn to Nadezhda. Nadezhda works for WTO, World Trade Organization, and deals there with intersection of trade policy, IP, and what should become global competition regime, which was very promising idea within WTO. Nobody supported, and so it didn't work out. Probably there could be another hope. WTO becomes less and less relevant to the regulation of the global trade, so probably they can endorse finally competition law, so because it wouldn't make any harm. So Nadezhda will tell us what WTO opinion about this, and no, I mean, you're not speaking on behalf of WTO, of course, because, but still, your takeaways.
Thanks so much, Alexey, and thanks so much for having me here. And it's a great pleasure to be here also because I'm alumnus of Higher School of Economics. Can I just the pointer? Yeah.
The pointer. Okay.
Yeah.
Sorry.
Thanks.
Okay.
So I work in World Trade Organization, and actually Alexey made already a good introduction of what I'm doing there. So my division is called Intellectual Property, Government Procurement, and Competition Policy. So how we see that in the WTO, and actually how our WTO member states see that, because WTO is member-driven organization. So we in the Secretariat, we do what our members are saying us to do. So all these three areas are intersect to a certain extent. And okay, let's skip that. Let's start here. So for people who are not familiar with WTO agreements and what we actually regulate. So we regulate trade in goods, trade in services, and organization was established in 1995. So you can imagine that at that time, digitalization, well, things were emerging, but discussions were not happening at the level they're happening now. Then we talk about e-commerce, digitalization, and relevance for competition, etc., etc. So there is no specific agreement in the WTO dealing with competition policy. So there was attempt to build one after the creation of the organization in 1995. So there was a working group of the interaction between trade and competition, which worked for 6 years, from 1997 to 2003. And this group was mandated actually to make research and look at the intersection of trade and competition policy and how competition policy issues are actually relevant for trade, because WTO is a trade organization. So at that time, WTO Secretariat made research in cooperation with member states and actually looked at the challenges members are facing in terms of coordination and to which extent coordination on international level is needed. So what was the situation back in 1997 during this time period? At that time, only around less than 40 countries actually had competition policy regimes. developing countries many developing countries didn't have competition policy regimes, or they were just at early stages of developing competition laws. So that was a new subject for many countries. So if now we are addressing how to help small competition agencies in 2019, so you can imagine what was there in 1997, then these issues were discussed. So of course the whole discussion was led by developed countries. And at certain point, it was clear that countries in the organization, they cannot move forward to establish certain even non-mandatory disciplines in this regard. Also, another point here, if I'm saying that many countries, they didn't have competition laws and regimes at that time, many countries were not even WTO members at that time. So if we talk about Russia and China, they became WTO members much later. And now what we see, what Brics countries are doing in terms of trade and competition policy, that's really interesting trends we are observing. So perhaps subject, always in WTO Secretariat, we are saying that all of the discussions are subject to member states' decision. So if there is an understanding of member states that this WTO working group should restart discussing these issues under WTO umbrella, that's can be their decision to come back to this organization. So what we actually saw since 2003, then this working group stopped these discussions and doing research on these issues. Countries which were adopting competition laws were increasing. So the trend was upward, so from less than 40 competition laws which existed worldwide at that time, now more than 130 countries, they have competition laws, and they are developing great instruments in terms of competition policy, treatment of IP, digitalization. So this we see a really evolving trend here. But why I'm here and why I'm still talking to you about competition policy if this working group is not any longer there, and why my division is there is a wording of competition in there. That's because you cannot imagine trade happening without competition. Of course, there are certain concepts which were put in other WTO agreements at that time that an organization was established. And of course, in terms of principles and different instruments, different elements, different WTO agreements have certain provisions which are linked to competition policy. So this we can see in General Agreement on Tariffs and Trade, Services, in TRIPS agreement dealing with IPs, and in agreement on government procurement. So this is a very important consideration, and this is something to remember about, that there are already certain elements which countries, specifically in TRIPS agreement, where there are direct provisions which are addressing anti-competitive conduct. So there is certain scope for member states to use and address anti-competitive practices. But we don't have a specific competition policy agreement. What we see as well in the WTO recently, that despite the fact that there is no specific agreement, different discussions are happening in different committees and councils in the WTO. So, for instance, we have trade policy reviews, then all WTO members are assessed, and competition policy is a regular part of this trade policy review, so you can go to WTO webpage and open trade policy review of any country, And you can see that competition policy section is there because there is direct relevance to trade. Another area is WTO accessions. I will not stop here, but it's just relevant for countries which are still not members of the WTO but acceding. So there are certain demands they are facing on the side of competition policy while they are acceding to the WTO that relates to state trading, things like this. And as well, TRIPS Council. Here, what we see recently, based and building on what is there already in the TRIPS agreement in terms of competition policy IP interface, we see the trend that member states are starting to bring these discussions on competition policy IP interface into the TRIPS Council. And of the most recently, South Africa was very active to bring this discussion in relation to public health issues. And since last year, as a regular item in the agenda of the TRIPS Council, we have discussion on relevance of competition policy to public health issues. So another area to remember, and I know that what I'm saying now, it's not directly, it's not only about digitalization, it's about regulation of competition policy in general, about coordination with regard to competition policy in general, not only specifically with regard to digitalization. But as we see here, there's so many issues to discuss and to cooperate about, and what we actually see, we still need some coordination and discussion with regard to competition policy in general, and then digitalization is kind of another step in this regard, or things can be taken into account very broadly, of course. So what we see that competition policy is included quite actively recently into regional trade agreements, and this trend. So you see here, we were making research last year about the treatment of competition policy in regional trade agreements. And if you see on the graph, dark blue is inclusion of competition policy chapters in regional trade agreements. And you see this upward trend happening, starting more or less at the time that the WTO working group on competition policy stopped its operation. So 2003, 2004, you see that countries are starting actively to include this subject to regional trade agreement. So what we understand here, there is a clear recognition that competition policy is relevant for trade issues. And of course, the whole movement of trade to e-commerce, digitalization makes it even more important. But that's the trend we observe, that even then countries were not able to reach to conclusion under umbrella of the WTO, they still started to build certain cooperation on regional level, on bilateral level, and include this provisions in regional trade agreements. So just the numbers that we assessed, around 280 RTAs at that time, and around 80% of this number included dedicated competition policy provisions. So what I mean under dedicated, they included areas about transparency, adoption, maintenance of competition laws, SOE, so that's very dedicated provisions on competition policy regulation. And Eurasian Economic Union as well was in this scope, and you know that Eurasian Economic Union Treaty has very extensive chapter on competition policy as well. So what I'm talking about is not just the provision about cooperation with regard to competition policy. These are very deep and complex provisions which were included. Just before I conclude, I just wanted to stop here because you moved me to the direction to justify how WTO is dealing with these issues in terms of competition policy. So I skipped that slide. So I actually wanted to start with the fact that last year WTO made World Trade Report. So WTO is making World Trade Report annually. It's an annual practice. And each year, WTO is focusing on different areas. So last year, the subject area was digitalization. So the report is available on the WTO website. So as you can see, even, like on the agreements that I'm listing, these agreements that I'm talking about, goods, services, IPs. So this agreement this report actually shows all of these different dimensions and how digitalization is relevant to this dimension. And the specific part of this report is dealing with competition policy. So what I'm trying to say that there is a huge importance of research work and what's being discussed today. That's great that these things are being developed because we need to share experience. And as you can see, the organization was our organization was established in 1995. So we are also learning from our members. So we are seeing what's happening and how rules which were established back at that time, how they can be modernized and how they can address new issues like digitalization, e-commerce. So these are very important points to take into account, that we all need to share this experience and have this discussion coordination. And there is a very big role of organizations like ICN, UNCTAD, OECD, which are doing extensive work in this regard. And actually, what we see in some other research we have been doing that actually the convergence of principles and approaches of countries in terms of competition policy treatment is happening. So countries are moving to that direction. There's more commonalities than differences. So what Svetlana was saying, for instance, about per se rule of reason approaches, what we did one research about competition policy treatment, competition policy IP interface, and we looked at different sets of countries. So what we saw that with time there is then countries are establishing competition policy regime. Usually it's per se approach, but then with time rule of reason is evolving. That happened, for instance, in Asian countries and in developed countries like US, European Union as well. We're using per se approach to certain issues. And we also looked at Brics countries, which are learning, actually. What we saw that Brics countries, while they are establishing certain principles with regard to IP, with regard to digitalization, they are learning from what other developed countries were doing as well. So, and if countries are learning from each other, there's certain level of convergence is happening. So there is, we see hope that there is more similarities in what we are doing and in what we are discussing. Thank you.
Thank you, Nadia. So do you think WTO would have competition law treaty one day?
Depends on our WTO members, but as you see, competition policy is a very different animal now comparing to the times that this discussion actually started.
Thank you, Nadia. We have a saying in Russian that when baby has 7 nannies, so nobody taking care of the baby, basically. So we see with competition policy, everyone is trying to deal with this, and WTO and UNCTAD and WIPO and everyone else. And so, and it's actually interesting that when competition lawyers always saying we have to focus on consumer welfare, some simple standards, they kind of, they try to be exclusive in a sense. But at the same time, everyone else is taking care of competition policy, like trade organizations, intellectual property organizations, and there is no any complaint about this. Like, okay, trade guys, please structure our competition policy. We're fine, or investment people. So there is certain inconsistency with this. Okay, so last but not least, Marek. Marek actually works for quite a while for developing Martyniszyn, because I learned that it's sh, not z, it's sh, Martyniszyn. So Marek Martyniszyn is from University of Belfast, but actually was doing a lot of work on developing jurisdictions in terms of establishing competition law regimes, and did quite extensive study of Polish experience, where he's from, and other countries, I think including Brics, or some of the Brics. And Turkey, for instance, which is not Brics, but Brics Plus, sort of, they attend all the summits. And Marek has some insights about how competition law could be adjusted to other policy strategies, and how it could be, put into the this repertoire of policy approaches. Thanks.
Okay. Большое спасибо. I appreciate this opportunity. My research really focuses on transnational anti-competitive conduct and the challenges posed by such anti-competitive conduct. My approach is institutionalist and it's informed pretty much by legal realism. And I hope to offer you a brief global perspective, as the title of the panel suggests. So it's quite interesting, because we did not manage yet to sort really old economy problems. Anna is meeting here to talk about new economy problems, which is great, because of course it's created this opportunity that perhaps an invention which solves old problems. Let's remain hopeful. As an academic, I always skeptical. And you will see that in this brief presentation. Because the pre-existing regulatory framework seems to be pretty poor internationally, globally, and it seems, in my view, to work only for the big guys, big and powerful. Right? So it may work for Brics, but Brics are big and powerful, right? And in my view, they will be now vested with special responsibility to try to realign the system as we have it. Now, generally, from the presentation so far, it's clear that we have different problems, and that different challenges, different groups of countries are facing different challenges, right? So a discourse on competition law in this room is very much different than when you have people from the US and European Commission meeting. And a very different discourse you will have at UNCTAD, right? When you have more agencies which are facing more fundamental problems. So it's quite important, because we're talking about global competition law, but there is no such thing as global competition law. There are global competition laws, or maybe global problems affecting different groups of countries, and how you go about it. And I think that's quite important to know. I think I'm delighted the way Alexey scheduled me at the end, because I can build on previous presentations, which I think tie really nicely. So I wanted to relate to Svetlana's point, right, about the fact that harm in one jurisdiction, so harm overcharging consumers here, benefits producers elsewhere, right? And that's basically transfer of wealth from one country to another. And perhaps not surprising that the country hosting violators maybe has no incentives to do anything about it, right? And it's quite important, because we sometimes lose this important message that within a domestic economy, in a model, anti-competitive conduct is wasteful, because we have, dead weight loss, which we don't know what it is, but, that's the thing on the chart. And then it's a transfer from consumers to producers. But when it's global, it's not like that, because it's transfer from consumers here to producers there, right? So money is flowing. And I think that's quite important. And I think it's also, Alexey really did me a great favor by scheduling my talk after Nadezhda, because Nadezhda already told you that actually we don't have a multilateral framework to deal with competition law. WTO tried to establish that these were different times and nothing has happened, and nothing emerged out of that apart from cooperation, and I will relate to that in a second. So what we have, and Nadezhda also mentioned that, is that we have now trends toward regional agreements, regional deals, and basically it reflects realism, that you need to be bigger to do something about it, right? If you are small, maybe Google won't care, right? So you need to have that vacuum to apply your law effectively. So given the lack of multilateral enforcement mechanisms, what we are left with is extraterritorial application of domestic competition law, so transnational cases. They are, of course, much more complex than domestic cases. And then I will refer to Pierre's point about capacity constraints. If you have an agency with 20 or 30 people, and you're struggling with a domestic case, domestic cartel, how are you going to chase after LCD price fixers in Southeast Asia? How are you going to get hold of evidence? By the way, I'm sure all colleagues in this room know that even very mature and developed agencies don't exchange evidence. Even Department of Justice cannot exchange evidence with, DG Competition. They can't. The EU recently concluded this new agreement with Switzerland, which allows them to exchange evidence, but only in cases on which both agencies work. So where DG Competition is investigating Swiss cartel, which is not investigated in Switzerland, Swiss Competition Agency is not going to render assistance. So even in these long-standing relationships, we don't have that cooperation, right? So these transnational cases are really extremely difficult. What I recently done is really looked into, in the framework of UNCTAD Research Partnership Platform, I ran a project empirically investigating what developed world is doing when it comes to extraterritorial enforcement of competition law. I had 40 countries participating, including all Brics states, right? So actually it seems that we have some growing action. Over 34 countries out of 40 actually provide for extraterritoriality, so they can, in principle, do so. But for example, Indonesia, which is a G20 economy, doesn't. So if you are an international cartel and you affect Indonesia, the law doesn't allow them even to apply competition extraterritorially. So how, so this is a sort of, basic level problem which is not yet sorted. So if we don't sort that, we cannot get to the high-level stuff which we've been discussing in this room, right? But most countries can in principle do that. Some have some jurisdictions in bringing transnational cases. So out of 40 cases, I looked into 40 countries which participated in my study, 13 jurisdictions brought some multi-party conduct cases. So brought some transnational cartel cases, 13 out of 40. Bringing them doesn't mean they were successful, but they decided to do something about it, right? And there is I asked them why we have so little action here, right? And of course we have capacity constraints, but lots of the problems that agencies are facing in many countries are sort of basic problems you would not think that they still exist. We in competition law tend to sometimes focus solely on competition law and forget that we have to think about all the rules in the chain of enforcement, right? So it transpires that one of the huge problems some of these jurisdictions are facing is service of process. Even Japan, a major economy, until recently the JFTC was unable to serve process on foreign firms. And we had cases when they investigated agreements between domestic and foreign price fixers, but punished only domestic parties because they couldn't serve process on foreign violators, right? So there are things which we can fix domestically to make the system work a bit better. They relate to rule of process. They also relate to seeking and rendering assistance. So it seems that most countries work on the presumption that you need to have a dedicated international agreement to allow for such intimate cooperation. I'm not entirely sure where that presumption comes from, but that doesn't have to be the case. We have in some countries we have something called information gateways. For example, in Australia, where Australian competition agency is able to unilaterally share evidence in cases whenever they are requested to provide assistance. Right? So we have examples where agencies were able to overcome such limitations. But of course, more work needs to be done. We need more collaborative efforts. What is quite interesting is that we are seeing also in this context an emerging trend of some jurisdictions, especially Brics, being much more assertive in this space, bringing more cases and bigger cases. And it's quite interesting because we also seeing a response of the pre-existing regimes. So I just came back from Fordham, where U.S. Assistant Attorney General Makender Rahim was delivering a keynote. It was quite interesting because he was talking exactly about this, about extraterritoriality as practiced by the U.S., about the response of other jurisdictions and blocking statute, limiting that, and then on how collaboration, cooperation emerged out of it. And then he started talking about the need of committee, that we need committee. We need to take into account what we're doing. And it seems to me not a huge stretch to say that, to see this departure from a unipolar, or to see that return to committee as a consequence of the departure from unipolar antitrust war or bipolar antitrust war, right? Because now we have at least a number of countries, principally Brics, which are able to apply competition extraterritorially and are able to do something about transnational anti-competitive conduct, including the likes of Google. And this brings me to the final point I would like to make, which deals with remedies, right? Because, as I said, there is no global competition law. There are global competition laws, perhaps. And I also don't think there is a Google. There are Googles. Because quite often in those cases, especially new economic cases, you may have remedies which can be only local. Because, developing countries were in past often advised, oh, you don't worry about this transnational conduct. Developed agencies will deal with that, and you will piggyback on them, on their efforts, right? So they will crack the cartel, you stop operating, and you'll benefit from that. That may sometimes work when you have truly global cartels, but of course some cartels are just local, like cement cartel. Cement cartel in Southern Africa, won't be challenged by European Commission. And price fixing affecting Southeast Asia won't be challenged by US DOJ, right? So there's no scope for free riding. But even for piggybacking or free riding, however you would like to call it. But even when you're dealing with truly global anti-competitive conduct, let's assume that one of the big high-tech companies is engaging in some anti-competitive practice, it may happen that remedies, any imposed remedies, will be only local, right? So you may have a situation that was argued in Empagram in the U.S. Supreme Court in the context of price fixing, that it may be still beneficial to do something anti-competitive everywhere and pay fines on some markets, because that would be just a tax on doing business elsewhere. So you can still overcharge on most of the markets to subsidize, and cover the costs in the developed markets. And of course, this is problematic. I know that we've seen at least some cases when agencies try to impose extraterritorial remedies concerning the use of IP rights, and that's the other end of the spectrum, right? Where someone actually wants to regulate what's going on globally, and perhaps that's a step too far. But I think that's one of the options which at least incentivizes developed regimes such as US and EU to think harder on how to realign the system, which probably is not working for us as a global community, given that this panel was to offer a global perspective. Thank you so much.
Thank you, Marek. And I do think that still we can jump from, as we were saying, feudalism to communism. I don't know, from underdeveloped regime to digitally enabled form of competition enforcement. I don't think there's gap is definitely requiring to go step by step, in traditional manner. And we see it in digital economy itself when people, as Yanis was saying in the morning, without financial literacy, basically starting to deal with fintech companies rather than traditional banks. So maybe authorities can do this jump as well. But it's extremely important, I think, this discussion about transnational global framework, which we're really missing, because it also contributes, the lack of this policy, to so different and sometimes opposing approaches towards new phenomena, because each authority has to deal with this. And the way they're dealing with this new reality is pretty much depend on the capacity they have in terms of if I can't hit here, I have to hit there tougher. So in this sense, it's sometimes they, in a position, they have to overreact because they can't reach the target by other means. So that creates this system of imbalancing the global economy to a certain extent. Okay, thanks a lot for all these contributions. I think we didn't go too broad as I expected. But we stayed focused, which is already a great achievement for this panel. And thank you very much. But we do have some time, a little bit, because we're not that much late. So just 10 minutes. 10 minutes. What is this in comparing to the digital revolution ongoing? Yes, and all these major challenges. So let's say 7 minutes for Q&As. Okay, if you have questions, please. Yeah, the first hand. It's Avrup.
So it's a question to both Marek and Svetlana. I'm deliberately trying to be a little provocative here. So, what is the virtue of cooperation? Specifically in non-merger and non-cartel cases. You kind of hinted that there exists a difference in terms of the jurisprudence. If, for example, it's coming to my mind, so I'm speaking out loud. There was an entire debate, within American scholarship about in terms of constitutional law as to why they should not quote foreign precedents. I do not know whether everybody's aware of it, but there was an entire school of thought that we should not overtly rely upon foreign judicial decision making. The question I ask more precisely because you have this pattern of the same respondent appearing in every jurisdiction. Two of them comes to my mind, Google and Qualcomm, which kinds of goes through the same process again and again. And many of the so-called minor jurisdictions or less advanced jurisdictions is under lack of resources, peer pressure to mimic and look as important as their developed ones, and evolve a theory of harm without really looking at what that economic factors are. India is a country of implementers, so should it have the same law for standard essential patents as America does? Might not. So, so I am really trying to ask you that why should nations cooperate specifically as far as abuse of dominance, and rather than not develop their own theory of harm based upon their own unique economic circumstances?
Murilo mentioned that Brazilian competition law is quite equipped to deal with digital markets. I wanted to ask, how are other laws, where do other laws fall short for digital economies like, EU or US or relatively newer law in India, but which is largely, based on those two?
Very short question for Nadezhda. I'm not familiar with WTO law that much, but you mentioned that there are certain trade agreements that do mention competition in competition law. So let's say you have a cartel in country A, which is not being prosecuted. Why? Because it's an export cartel. They're like, we make money out of this, like your colleague on the panel said. Can country B then said, then we're going to stop trading with you. This is an infringement of trade laws. We have competition law, but we're not going against the companies here. We're going against trade from your nation. That's my question. So
Pierre and then Nicola.
I just wanted to say, since this is a global policy response, and I think we need to also talk quickly about what has been recently approved at the level of the United Nations in July. Just as a matter of comment, the member states of the United Nations have approved what is called the guiding principles and procedures for international cooperation under Section F of the UN set. This was a original proposal by the Russian government 2 years ago, in 2017, and this has been widely negotiated by member states around discussion groups, and we have been very much active in making that this is happening. We have actually a combination of very smaller agencies and bigger agencies negotiating on the table during 2 years, and we managed to get an agreement on what international cooperation should be shaping for the future. And these guiding principles and procedures under Section F of the UN set, which is precisely international measures, talks about guiding principles, a toolkit for cooperation, and the role of the UNCTAD Secretariat in facilitating cooperation. Just to very brief introduction on this, when it comes to cooperation, it's about cooperation of national competition authorities or regional competition authorities that have been empowered by the member states. And when it comes to these principles and procedures, it talks about guidance to many countries to basically negotiate with mature agencies in the area of having more cooperation when it comes to any type of practice that affects competition, whether it's cartels, unilateral conduct, or even mergers. The second thing I would like to say is that this document has principles that are basic for many authorities. They are very basic, actually. But nevertheless, it's the first time that would be crystallized in a UN document that will be able to be followed by any member state of the United Nations. And finally, the last point is that for the first time, member states are considering to give more prevalence to the UNCTAD Secretariat in terms of facilitating consultations. And that means, in other words, that if it's a cartel, international cartels, and let's imagine that the Republic of Kiribati, a member of the United Nations in 1999, wishes to negotiate with the EU, and of course the EU will have this competition authority, let's say, accepting it to negotiate, the UNCTAD Secretariat can facilitate this negotiation at the level of providing the premises to negotiate in Geneva. That consultations will facilitate cooperation and will put a leverage between a very small competition authority like Curaçao or the French Polynesia and to sit down with the very big authorities, including the Brics. So we are happy to see that many of the Brics competition authorities, actually all of them, the 5 members of the competition authorities were actually very actively supported in this process, and we're happy to see that, I hope, in the future, we'll be able to use this document that has been approved by its own member states. Thank you.
We go just very short question to Marek. So you talked about the problems in cooperation, exchange of information between authorities. We heard from our colleague here that there are issues in accessing data about public procurement for competition agencies, and you can also see similar issues with regard to cooperation between competition and data protection authority, consumer protection authority. We saw the Bundeskartellamt case with Facebook, but there's many others along those lines. So do you see maybe the evolution of cooperation also going in that direction at the global level?
I think we just go one by one. Yeah, we'll maybe start with Svetlana, and then in the same order, like answering all these questions. Everyone picks what prefers.
Just a small remark on the question about cooperation between competition authorities. What I actually told about is not precedent as it is in US. What I told about is coordinated actions of competition authorities. As in digital area, business models of different companies are based on information, on internet communication, and they easily cross borders. So they are present in different parts of the world. So efforts of one particular authority are not enough to protect competition. Joint efforts are needed. And the question is in which sphere such joint efforts are possible, taking the difference in institutional environment. Well, they are possible in case of some mega mergers due to relative harmonization of competition law in this sphere. It is possible, as I see, to share information, as it was mentioned by Alexey, for example, that companies provide different sets of information to different competition authorities. So actually it is a question. Actually, it's confidential information. Is it possible for competition authority to exchange this data to make better vision of situation and what is actually going on? Talking about algorithmic collusion, if some algorithm is identified by some competition authority, it could be a good idea to share this information with others, and they could undertake some common actions, just trying to solve the problem, to develop. Actually, I'm still waiting for the answer on the question if algorithmic anti-collusion is possible. So thank you.
Thank you very much for the question. It's quite interesting, and it gives us the opportunity to comment on the Brazilian approach. So how Brazilian law is different from, or is wide enough to cover situations where other laws might not cover. Let me give you an example of in merger control, as Caio highlighted in the morning. We have not only the possibility to tackle the mergers that are within the threshold, but also to require that mergers that do not reach the threshold are presented. So this is quite important for digital mergers of mavericks, like small innovative companies. The other example, when it comes to conduct, the law requires any act might amount to a breach of competition law, irrespective of the effects. Other jurisdictions might require the existence of an agreement or a meeting of minds, for example, and this is also helpful to make a finding of violation. On the other hand, we have the guidelines and the practice of the law, and I think that in that regard, the cooperation and this initiative will certainly help CADE to bring more theoretical sophistication in the analysis and new theories of harm, to be able to update the guidelines. So there is some possible outcomes that would help antitrust enforcement in Brazil, because Brazil is quite well equipped in terms of staff, has a decent budget, and there's a flow of work, and unlike in 10 years ago where there are some restraints, and we lived under a different law where there was a post-merger notification system. So in this respect, the situation is quite possible, and I think that for the future, an update on the guidelines to be able to differentiate to certain issues, and the cooperation in this remit is quite important. Thank you. So,
with regard to the question, what is actually in there in the WTO agreements that I'm talking, that there are some certain elements of competition policy already embedded in what we have in the WTO. So, the best example will be TRIPS agreement. That's agreement dealing with intellectual property rights. So in this agreement, there is specific reference that that WTO members they can address and take certain measures with regard to anti-competitive abuses of IPRs. So this is the best illustration of competition policy being addressed in one of the WTO agreements. Other elements which are there in general agreements on trade and goods, trade and services, these elements, we consider them, they are not you wouldn't find wording of cartel, of course, in the general agreement on tariffs and trade and services. And you wouldn't find competition policy there. So then we say that there are certain elements. We mean that these elements are linked to competition policy, and then they are relevant and they can be used. For instance, there are certain provisions on state trading enterprises about monopolies, export restrictions, and the most fundamental is non-discriminatory treatment. That's the most fundamental principle in all agreements. So with regard to your question, if you take an example of export cartel and how this issue can be addressed within the WTO framework, as I just mentioned, that there is a restriction with regard to quantitative export restrictions, so you cannot put export restrictions. So what scholarship is saying that situations as export cartels, though indirectly, they can be somehow used. And this provision, which is with regard to export restrictions, can be used to address export cartels. We don't have case law in this regard that it was brought into the WTO system, that someone is bringing that, and there is some proof of that. But this is one of the scenarios which might be. What actually shows that there's some provisions which are there, but they are not developed to address members' concerns fully. So here we are coming again to the discussion that rules probably should be modernized and extended, and competition policy. If you have certain elements which are already there, but you cannot really fully use them, maybe it's something what WTO members can consider and extend the scope of what they are looking. But just to reply to your question, then you are saying, so if sanctions are possible in terms of, you find that there is export cartel and you prove that and you just put the sanctions on trade. So how things work in the WTO, you find a violation. So in principle, if there is link to trade, and if you believe that certain provisions in the WTO agreements, and for instance here you can use the article which is on export restrictions, you come to the WTO, there is a dispute settlement mechanism, and you build your argument. So it's kind of the court where you try to prove that there is a violation of the WTO agreement. And if at the end of the proceeding, court is saying that, yes, indeed, this article is violated, you're winning the case, and then your opponent needs to bring the measure into consistency, or there are certain other elements which can be added at later stage. So that's kind of, if we look specifically at your example, what scenario can be. And just linking to this question and what Marek was saying, actually this situation and what you were saying basically about extraterritoriality, all of these issues we are facing, these are, then you are asking the question, so why should we be cooperating, right? So that's precisely why countries need the cooperation, and why we saw this trend where countries, even first on regional level, they started to bring these discussions and cooperate and find commonalities, that there is certain coordination in that regard. Because what countries are dealing with now are transnational corporations, cross-border trade. And these issues, they cannot be only addressed unilaterally. Then you're just, you have your competition authority and you address these issues. Then we look at all of these cases which were discussed today. Of course, there should be coordination with regard to these issues, extraterritoriality, etc., etc. So that's why kind of building on this, what countries already have in regional trade agreements, in other organizations where they discuss certain cooperation and coordination. Maybe this can be a potential to bring to further discussion sometime in the WTO. Thank you.
Thank you so much. All are terrific questions. I'm delighted because I published on all those topics, so I'm delighted to talk about it again. Why Europe? Why cooperation? Exactly because we want to prevent future harm. If you don't enforce, nothing will happen, and you may need to cooperate to do this. You'd like to, all these issues. You want to provide deterrence. If you don't take action, you don't provide for deterrence. You may be the repeat victim of what's going on, right? And that's what Nadezhda said on extraterritorial enforcement. It's very important. To realign the system, we really need to see more countries enforcing their domestic law, because that will realign incentives, that will pull pressure on multinationals, that will increase their costs, transaction costs, compliance costs, even if we have inconsistent outcomes. That's great, because that puts pressure on firms, to put pressure on government to sort it out at some other level, right? If you don't have that, then status quo works for the big transnational offenders. That's probably what we don't want to see. And why we need this extraterritorial enforcement as well? Because in some cases it really allows to claw back some of the exported harm, right? So we have this transfer of wealth, and we have a situation when maybe sometimes when you are talking about fines, some sort of fines, that brings back some of the exported wealth from the country, right? It's not an aim in itself, but I think it's relevant. Bjorn asked about export cartels, also published on the topics, and Nadezhda already touched upon this, right? So we have Article 11.1 in GATT, and we had a case, Japan trade in semiconductors, focusing on restricting exportation of goods below certain prices, and it has been argued that this can be applied to export cartels. And this has been done by a panel in China, measures related to exportation of various raw materials. Very important case, so the rare earths case, which was both trade and competition case. And the findings of the panel was great. I encourage you to study the panel report. However, the appellate body, on procedural grounds, found the panel findings moot and of no legal effect, right? So actually there was some push in that direction to do something in WTO, but it failed at the appellate body level, right? And of course you could always bring this non-violation complaint, but we never seen that happen because it's just too difficult. The system is not functioning. And if you look at it from the realist perspective, which Nadezhda probably working for WTO, as academic, it's easier for me to say that, but appellate body is not working, right? Right? So, the system is just collapsing, right? Procedurally. So, maybe the solution should be found somewhere else. I really appreciate Nicola's question about cooperation between different types of agencies. That's quite interesting and a good idea. Of course, as a legal realist, I would say, and that's informed by my empirical research, is that even within a single country, ministers would not have a clue typically what competition law is about. They are appointed, and they have to be taught by heads of agency what the agency does, right? Quite often when you have public procurement separately, people don't know how it works. I recently finished a long empirical project on Poland, investigating introduction and development of the regime in Poland, when I spoke to all former heads of the agency, judges and practitioners on that. And that was exactly the case when a public procurement regime in Poland has a criminal threshold, so it's very difficult to prove. Whereas some of that conduct would be illegal under competition law, which has a civil burden of proof, lower. So you could catch some of the people you couldn't catch on the criminal level, but people don't speak enough to one another, so sometimes conduct escapes scrutiny. So if we don't have that conversation going on internally, I don't think it's, I wouldn't be too optimistic to see that transnationally, but of course you can have people who will know about this and who may reach out, right? The question is, if we still have problems in cooperation between even competition agencies, even like-minded people, how difficult it must be to cross bridges between, the silos of different disciplines. Thank you so much.
Thank you very much. So we have to wrap up our session. We're already quite beyond our schedule. It's nice that we discuss this inequality not only in context of different type of social strata, but also countries. And this discussion, I think, it's very important for digital economy context that some countries are extracting value, some countries are extracted or get rid of this value. So it's very important element as well. So we finishing this. We have a 2-minute break or like 3-minute break, not more. And then our last session, which would last a little bit longer than expected, but yeah.